Direct from the Golden Hill Broadcast Center, this is Talk of the Town on KNSJ with former San Diego City Attorney Mike Aguirre and attorney and former political science professor Douglas Holbrook.
This is Mike Aguirre.
And I'm Douglas Holbrook, and once again we are back on Perspectives with our intent to pull back the curtains and through this show show you what's going on behind the scenes between this interaction between the government and the people, the population. And Mike, you know, we often hear people say, hey, you can't do that. That's against the law. Do you want to talk a little bit today about what the law is, what its purpose is, the role that it plays, whether it helps or hinders? I mean, there are some libertarians who tell us we have too many laws. And then there's other people on the left who say we don't have enough laws. And I guess you can take any position you want. What's yours? Too many laws? Not enough laws?
Well, you know, first I think we might want to ask ourselves, what is the law? You know, when we say the law, and the law really is a commitment to using reason and experience and wisdom to reconcile and resolve conflicts under a system of justice. It's a, you know, the law it derives from, or is created. The laws are created in two basic ways. The original way was by way of a conversation, what they call the rule of law, and that conversation was a learned conversation carried out by jurists, primarily in England and in the early history of the United States, in which specific controversies were addressed and resolved following rules of justice.
How far back are you going?
Well, I'm talking now back to really the 16th century.
Well, if you wanted to take law back to its primal, origins, wouldn't you go back to maybe 10 statements that came off a mountain? I think we called them 10 Commandments. Would that maybe be an earlier version of the law?
Yeah, of course you could. But what I'm talking now about is in modern day. The modern law, the legal process as we understand it today, really started off as a conversation in what was called the rule of law. And the rule of law, as opposed to the rule of a king or the rule of a tyrant, in the land of one of the great inventions of the English was the common law, and the common law was originated and expanded and evolved as part of a conversation. And for example, if someone entered into an agreement to perform or provide and by a certain date, and then they reneged, there was the original cause of action for breach of contract, to put it in simple terms. And the idea was that if you had a specific agreement and there had to be a offer acceptance, the offer had to be clear and it had to be, the acceptance had to be binding. But if you had a contract, then the failure to perform the contract resulted in a finding of a breach, and then a remedy of either forcing you to have to perform the contract or having to pay damages. And that's how the law started.
Well, to frame it so that our listeners can sort of follow what we're doing here, you made a comment, and I think it was a very profound one. The distinction between the first laws, which were the laws out of the mouth of a leader, be it a king or the strongest person in the cave. So the law started out as the words out of someone's mouth. It was, you have to do this, you have to do that, sit there, shut up. And then somewhere along the line, and I think it was maybe the British or maybe it was the Romans, who came up with the idea that better than the law of a person or a king was, maybe the rule of a person would be the rule of law.
Right,
laws were put down. And so I'm trying to figure out, where did the rule by person sort of get modified, or at least where do we get the alternative rule by law versus rule by person? Because that's a nice distinction.
Well, I think that what you're really talking about is the evolution of. You can kind of track it with the evolution of Parliament and the the British Constitution, which doesn't exist in any single document, the Magna Charta, where the royalty became more of a symbol, and the substance of law was taken over by Parliament and by the courts. And then to make it a little bit more complicated, one of the great things to ever evolve out of Western civilization were the equity courts. And the equity courts said, our primary focus is to be concerned about justice and right, and not just about the law as a strict set of rules. But the laws have to serve justice. The ultimate goal of law is to serve justice. And then as time has passed, what has happened is the rule of law, as it was developed by learned judges over long periods of time, each judge building on the decisions and the rules of the prior judges and attempting to use that as a precedent to apply to a new situation, and then altering it as the particular circumstances change. As that learned process was moving forward, we had the creation of legislators and legislatures here in the United States. And then what's happened is that the legislative process in many ways has overtaken the rule of law by judges, and now we have the rule of law by lobbyists.
Oh dear, I didn't know that's where you were going.
And lobbyists now have more to say about the laws that come out of Congress, the laws that come out of our state legislators. And if you think about it, on the one hand, would you rather have the law by a learned person who is steeped in the tradition and is respectful and trained in helping to develop the law in a learned process in which you can influence the outcome of cases based upon the quality of your argument? Or would you rather have it influenced and developed by lobbyists and by judges who are appointed not because they're committed to the rule of law in a fundamental or philosophical way, but because they're there to carry out a certain agenda? Our current Supreme Court majority is a perfect example. They're there right now to make sure that concentrated wealth becomes more concentrated. They want to help the migration of the money from the many to the holdings and the wealth of the few. And they're committed to the idea that the people who own America are the ones that should run America. They don't believe in fundamental rights. They don't believe in restraining corporate abuses. They don't believe in the jury trial. They don't believe in the rights of the public to be able to have voting rights. And so we are, we're kind of in a dark age of law. And people's respect for the law is dissipating because it's less to be respected because of how it's being manipulated. And we're losing our ability to use the law to bring about fundamental reforms. When we passed Social Security, that was a fundamental reform. When we passed the Health Care Act, the Obamacare as they call it, that was a very minimal kind of change in the law that created more heat than it should have. I'm not saying it was a bad thing, but it certainly wasn't the same thing as Medicare or as Social Security or other broad-based social reforms that we've been able to achieve in the past.
For those of you who are just joining us, I am Douglas Holbrook.
And this is Micah Geary.
And we're here on Perspectives today talking about something that certainly needs perspective, and it's the law. And the concept of law and its source and its basis, and what I think I've heard from you, Mike, in the last maybe 5 or 6 minutes, is you've kind of followed an evolution, going to the primal source of where the law comes from. I guess in its first instance, it was the Word of God, divine law, and then of course he passed it on the idea that the divine right of kings, God made kings the rulers, and so we had the rule of kings, and we thought that at least provided some kind of order. And then over time that developed into the notion, I guess the competing idea that you could have rule of law aside from the rule of the king. And then from that you've indicated that it spun off into the common law, And from that, we developed legislatures to write law, and then in between the areas where the legislature didn't have enough specificity, the courts stepped in and began to elaborate on what the law was. And then you took it to the next step, caught me off guard, and talked about not the law of the courts, but the law, I guess, going back to the legislature, the law of the lobbyists.
Well, we have
with their private agenda, and perhaps the notion of who's really running America, and if their private agenda is to keep wealth concentrated, and in a time when we appear to be moving into the dark ages, some might say it's darkest before the dawn. Is there a dawn coming? Is there something that the law could do to save us from this road that we're on?
Well, they say, Martin Luther King used to say, the arc of the moral universe is long, but it bends towards justice. And Franklin Roosevelt, in his last speech to Congress, talked about that there was always an upward trend in the development. But I want to clarify one thing in our listeners who are thinking about this. Our Constitution enshrined and created 3 branches of government, as we all know it. And one of the branches of government was the judicial branch. Now, when the legislative branch can create laws and the judicial branch can create laws, but there are certain laws that the judicial branch or that the legislative branch cannot create because it interferes with the judicial branch, and vice versa. But what has happened is the common law was something that was developed as part of the rule of law. It was an outgrowth. Oliver Wendell Holmes wrote a famous book on common law in which he said the law is not based on logic, it's based on experience. And that's what the learned jurists, even in the time of the rule by kings, there were the equity courts and the courts of that were connected to sovereignty of the king, and there was always a learned process, or not always, but there evolved out of that a learned process. So even when you had the kings in with the divine right of kings, you had the development of the law that protected those who were in the court and who were part of the court around the king, and it's out of that the learned jurists and the development of law and the what we call the law by precedent evolved. But nowadays what we have is in the United States we have both our federal and state constitutions that create these different branches, and the judicial branch and the legislative branch both create laws. The judicial branch interprets laws, but what we have is that the people that control the judicial branch now are so heavily committed to concentrated wealth. Both political parties appoint more and more judges that have to pass the litmus test of, I when they take their oath of office, one of the things they've now added is I swear that I will uphold the rights of concentrated wealth above the rights of the people. And it's not, I'm being facetious, but there is some truth.
I thought you might have been kidding.
No, I am kidding. And the same is true with the Supreme Court. And then on top of that, you have on the legislative side, the lobbyists basically write the laws. And you hear, oh my God, hear all these arguments. Well, the lobbyists are in there with their lawyers, and they're the ones that write the laws, and they're the ones that make the political contributions. And so now the law has become muddled. It is not, and when people say there are too many laws, there are too many laws. There's too many exceptions. There's too many. And one of the things that Gibbons wrote in The Rise and Fall of the Roman Empire is that when you have so many laws, when you have to define what's right and wrong in so many different ways, there's something fundamentally wrong with your society. There's a loss of commitment to honesty and to justice. And
sometimes more laws or more laws on the books is there to add specificity and detail. To get us away from just laws of a general nature that leaves too many gray areas. By the way, if you out there are just joining us just now, I'm Douglas Holbrook, and facetiously, I'm here with
Micah Geary.
when I say facetiously, that really should be my own. It should be said about me, not Mike.
Well, no, that's I accept that. I accept that,
But we're talking about not the law itself, but the concept and the nature of law, and it is such a, I mean, it's a philosophical concept, but one of the things we're pointing out is Holmes's concept of law not being based on logic but on experience. And I know, Mike, the number of times you've argued cases before, well, whether it's at trial or whether it's on appeal, one of the frustrating things is when you make an argument to a judge that makes complete and absolute sense, they come back and say, well, what's the precedent for this? And you want to think to yourself, well, just because there's no precedent, can't we talk about sociological need, like they did in Brown versus Board of Education? Because the precedent said that separate but equal was fair and appropriate.
Well, the law. But when you have to think about precedent in the law has a variety of different precedents that create fundamental principles, and those principles are capable of rearrangement. One of the things Franklin Roosevelt talked about is this simplicity and flexibility of our Constitution has allowed for readjustments that have permitted the march of progress. And so when you think about putting together a legal case, let's say that might not have precedent, but you always can find the precedent based on these fundamental principles to do what's right. That's been my experience. And over the years, there's a rule of law that says, and this is what's so great about it, you have an ethical duty if you think the law is wrong. A lawyer has an ethical duty to fight to change the law, to say, we shouldn't have slavery. We shouldn't have separate but equal. Women do have the right to vote. Women have the right to control their own bodies when it comes to...
But those kind of changes come through either the legislature or through the amendment process.
Well, yes and no.
When an attorney walks into a courtroom and says, here's what we should do, you are immediately confronted with a judge who's going to say, counsel, what's the precedent for that? And sometimes I don't know if you've ever felt like saying this to a judge. I want to say, well, Your Honor, the precedent is looking at what has not worked, and what doesn't work is the precedent. So let's fix that.
Well,
let's do what does work.
I would put it a little bit differently. See, if I go into court with a new way of doing something, I anchor it in precedent, and that's it's always possible.
Arguing by analogy,
right? It's always possible to when you structure the way you want something to come out. What you always do as a lawyer is you try to, for example, when there was a lawsuit that I brought, a voting rights lawsuit. In San Diego, and one of the things that I argued was that the precedent was clear that you couldn't violate people's right to select candidates of their choice, and then we went back over the years and we showed how that when the choices of the African American community ran, they always lost, and that was because the way in which the system was created. So we got the law changed, or we got the system changed. The new organization, we have district elections instead of at-large elections, and so the idea is to always find the precedent buried, some principle that you can then organize around, and that's what the moral and the ethical obligation is if the law is not what it should be, you have an obligation to try to argue why it should be different, and here's why, because there's some incomplete understanding of what the precedent really is. But that having been said, the point is that's an honest process, and what the problem is now is that we don't have a system that's based on the rule of law anymore. We have a system that's based on the rule of lobbyists. We have a system that's based on the rule of concentrated wealth. We have a system that's based on the rule that if you have a white collar and you are in the upper financial echelon, you have a different set of rules. We have law based on the fact that the stronger and the richer you are, the better lawyer you can get, and the poorer you are, you might not even have access to the court altogether. So, this is an area that is in need of fundamental reform. If we're to continue to be a society that lives under the law. And when people see the bankers violate the law wholesale, destroying the part of our financial system, and instead of being punished, they get bailed out.
They get rewarded.
They get rewarded. Then now
They
you've
get
done away with.
They get bonuses. If you're just joining us, by the way, I'm Douglas Holbrook.
And this is Micah Geary.
And we're talking about, I mean, on this show, on Perspectives, we go off in different tangents. And this really isn't a tangent today. This is really something that's very core, very primal, very essential. The law and what it's based on. And Mike, you keep coming back to the notion that we've gone from law by the legislature to law by the lobbyist. My question to you is, God, how did we get there? How did we get to a point where lobbyists are the primary source of what our laws are? If unless I'm overstating what you're saying.
No, I think what I would add one little thing. I would say that we've gone from law by the learned, law by the judicial branch honestly trying to find the right path, to law by the selfish, that is represented by the lobbyists. And I think, in
other words, law by the private interest as opposed to law from the public sector, which when Montesquieu gave us this three-function formula of executive branch and legislative branch and judicial branch, that when that, I mean, the executive branch can suggest what the law should be, but it's the legislative branch that articulates in the exact words, and then it's the judicial branch that comes in and sort of fine-tunes it. And you'd think, okay, that's the end of it, but it's not. And now you've got a fourth branch, the lobbyist, or the
loss of the other three.
Yeah, it's like the private sector has come in and sucked our law out of our system.
A certain part of the private sector, the executive branch enforces the law. The legislative branch creates the law. And the judicial branch judges and makes sure that the laws and the respective areas of authority are carried out within the Constitution, and where there's disagreement, helps to find.
I guess you could
what
almost
the
say
answers are.
they sort of test the law in some ways. It's like, okay, the legislature has written it. Occasionally, we're going to test it to see if it means what it sounds like it means.
Let's take, for example, antitrust law. Okay.
Cool, good.
Okay. Let's take as one area that there's really been a breakdown. The concept of antitrust law says that the distribution of wealth should be based upon a competitive market system. No one should be able to monopolize and then use their monopoly power to manipulate the system to take away from the general welfare some private advantage. That was the whole point of the antitrust laws. Putting it in the simplest form, if you want to buy if you want to buy a television set and you're willing to spend $500 for your television set, but in fact it can be produced and sold for $300, that means that you have the extra $200 because you can buy it for $3. You have the extra $200 and you can go buy videos, or you can go buy let's say golf clubs, or you can take family out to dinner, or you can put the money away for savings. You can do a lot of different things, but that's called consumer surplus. That's the difference between what you would be willing to pay, what you have to pay. And that's the greatness of our competitive system, is that prices should go down, like, for example, they do with televisions or cars. Over time, the prices should go down because we become more efficient in the way that we produce. But what's happened is the antitrust laws are not being enforced. Now, if you take it, and so you have products that are sold for more than what they should be sold. Housing in many of our communities are artificially maintained by the banks banks in the real estate industry at higher levels of price than they should be, because of restraining of trade, and because of monopoly power, and because of keeping the houses off the market. And so the idea of the law was to come in and say, we want the laws enforced and we want them carried out. But the courts have basically read the antitrust laws off the books. Same with securities laws. Those laws were put into effect to keep people from misrepresenting when they were raising money from investors. Those are, not only are they off the books, but we actually have the Federal Reserve system pumping billions and billions of dollars to make it easy for people to buy stocks, whether they're valuable or not, just so they can pump up the market and create the illusion that there's prosperity when there's not.
When there's really not. By the way, if you're just joining us, I'm Douglas Holbrook.
And this is Mike Aguirre.
And we're talking, and we're heading into the last few minutes of the show here. And I think what we're talking about is the failure of the law, because you tossed out securities laws and you tossed out antitrust laws. And I think literally we have tossed them out because of the various things that the law is supposed to do. I mean, it should be protecting the population. The law should be creating a connecting link within a society. It certainly it's supposed to provide maybe a social cement of some type. It's supposed to be a source of conflict resolution. It's certainly supposed to be maybe a code of ethics or an example of appropriate behavior. When you say, you can't do that, that's against the law. I think you used that as an example previously. But it's also supposed to be a avenue for reform. But what it seems to fall down to is it's become basically, when you think of the law, you think of, that's the occupation that lawyers endeavor in. And that's the last thing it was supposed to be. It wasn't supposed to be an occupation for lawyers to be charging the public to do certain things. And it's not doing the things it's supposed to. The courts have abdicated their role. And in the two examples you threw out there, and you were about to go into securities law, it's not doing anything it's supposed to. It's just lining the pockets of attorneys, and I don't really.
Well, it's not just attorneys. It's not just
I mean,
attorneys.
Yeah, I know it's been said.
That's a small part of it, actually.
But I know, and it's been said that 99% of the attorneys give a bad name to the other 1%. So I don't mean to unfairly.
No, but what I'm talking about, though, Douglas, is this: the law is being subverted by the people who have a fiduciary duty to participate in the rule of law, this wonderful history and heritage of developing the rules based on experience and learnedness. But in fact, what we have are people that are subverting the law, and the people that are making money off the law, or the subversion of law, the lawyers, yes, but that's minuscule. It's when you subvert the law and say that the Federal Reserve System can lend out $185 billion to AIG as an emergency loan, because it's appropriate under the Federal Reserve Act. That is a subversion of the law. When you allow AT&T to buy DirecTV and everyone looks the other way, that's because of antitrust, where now you have wiped out a whole competitor where there's not that much competition. That's a subversion of the law, and that's what we're talking about. We're not really talking about lawyers getting rich off the law, which they do. Certain lawyers do, but what we're really talking
it's
about
happening. We just aren't talking
is
about
these massive economic interests that have taken control of the law and are subverting it to their own selfish purposes.
I'm Douglas Holbrook.
This is Mike Aguirre.
And in the minute or so we have left, if you were to take maybe 30 seconds to kind of summarize the solution, or either the problem itself, because you have to talk about that before you get to the solution. But is there a way out of this? You said something about. Is there a way out of this, or is this just a topic for another show? And it may be, because we've opened the door or we've opened the Pandora's box.
Well, you could talk about
save us.
You could talk about Plessy versus Ferguson that said separate but equal. You could talk about Dred Scott and say that during the time that the people were talking about the law then, they would ask, is it ever going to get better? And it did get better. As I say, the arc of the moral universe is long, and I do agree, though, it bends towards justice, and I do think that we have better days ahead of us because we are able to talk about it. And we will do something about it, I have no doubt. I'm Douglas Holbrook. And this is Mike Aguirre. Reminding you that sometimes it is darkest before the dawn. And so I am looking to a time in the very, very near future where something that we discuss prompts another response, and someone will say, I'm mad as hell and I'm not going to take it anymore. And we're going to fix this thing. We are going to fix this thing. I have hope. I want to thank our listeners for being with us. Again, I'm Douglas Holbrook. And this is Mike Aguirre.
Thank you for joining us on Talk of the Town with former San Diego City Attorney Mike Aguirre and attorney and former political science professor Douglas Holbrook here on KNSJ Descanso 89.1 FM, serving San Diego.